Imagine this. You are admitted to the hospital. Your doctor diagnoses you with COVID-19. You need hospitalization. But then, your insurance company calls and says, "We do not think you need to be there. Go home." Who decides? The doctor who examined you? Or the insurance company reviewing documents? The answer just changed, and it is legally binding. For years, insurance companies have been overriding doctors' clinical decisions. A patient needs hospitalization. The insurance company says no. A patient needs surgery. Denied. The doctor says it is medically necessary. The insurer says it is not covered or not necessary. This created a fundamental problem. Who has the authority to decide medical treatment? The trained physician who examined the patient? Or the insurance administrator reviewing a file? Who decides? The legal battle has just ended. 3 landmark judgments, issued between November 2024 and September 2025, have answered this question definitively. First, the Ghaziabad District Consumer Commission, in November 2024, ruled explicitly, an insurance company cannot override a doctor's decision to admit a patient. The case involved a COVID-19 patient. The insurer said, "They are asymptomatic, they should stay home." The commission said, "No." The doctor examined the patient. The doctor decided. Insurance companies are not medical experts. They cannot second-guess clinical judgment. Then came the Kerala High Court, September 2025. This was the most authoritative judgment to date. The court held, once an insured person has undergone treatment based on expert opinion of a doctor, the insurer cannot arbitrarily reject the claim. Such rejection violates Article 21 of the Indian Constitution, the right to life. Let me be clear. This is not activist overreach. This is constitutional law. Your right to medical treatment is not a privilege granted by your insurance company. It is a fundamental right. This judicial shift is grounded in 3 critical legal principles. First, the Bolam test. This principle, endorsed by India's Supreme Court, says that medical decisions must be judged by professional standards, not by insurance administrators. A doctor is not negligent if their conduct aligns with practices accepted by competent medical professionals. Insurance companies are not competent medical professionals. They lack clinical training. They have not examined the patient. They cannot override a doctor's judgment. Second, uberimai fide, utmost good faith. This doctrine applies to insurance contracts. It requires that insurers act in good faith. But what does good faith mean when an insurer accepts premiums for years, then arbitrarily denies a claim arguing the treatment was unnecessary? The courts say, when you accepted premiums, you implicitly accepted the risk that doctors would make individualized treatment decisions. You cannot retroactively deny that. Third, Article 21 and the right to life. The Constitution guarantees protection of life. Medical treatment is integral to that protection. When an insurer denies a medically necessary claim, it is not just a contract dispute. It is a constitutional violation. So what does this mean for you, whether you are a doctor, a patient, or both? For doctors, your clinical judgment is now legally protected. When you make a treatment decision based on medical evidence, insurance companies must respect it. You are not merely following guidelines. You are exercising professional autonomy protected by law. If an insurer denies a claim, you have legal grounds to challenge it. Courts will now defer to your clinical expertise. For patients, your right to medical treatment is no longer subordinate to insurance coverage questions. If your doctor says you need hospitalization and the insurer denies coverage, you have recourse. Consumer courts across India have proven this repeatedly. In 2024 and 2025, patients successfully challenged dozens of insurance denials. Courts awarded them from 5,000 to 5 lakh rupees in compensation. For insurance companies, the era of arbitrary claim denial is ending. Regulatory bodies like IRDAI are enforcing strict timelines. Consumer courts are awarding damages for unjustified denials. Systemic overreach will no longer be tolerated. This shift reflects something larger. In a constitutional democracy, certain rights are non-negotiable. Your right to life is not negotiable with an insurance company. Your doctor's professional judgment is not subject to a corporate administrator's approval. When courts protect these principles, they are not interfering with business. They are enforcing constitutional limits on corporate power. The Kerala High Court put it starkly. Insurers often exploit policyholders' vulnerabilities during medical crises, defeating the very purpose of health insurance and eroding public trust. Courts exist to prevent exactly this kind of exploitation, and they are doing it now. So remember, doctors decide medical treatment. Insurers process claims. When an insurer overrides your doctor, it is not a business decision. It is a legal violation. If you are a doctor, document your clinical reasoning and stand firm. The law is now with you. If you are a patient, challenge wrongful denials. Consumer courts have proven insurers lose. And if you know someone facing an unjust insurance denial, share this message. Because this is a right you all need to know about. Your doctor's decision, your constitutional right. Consumer courts have your back. Like, subscribe, and share this with every doctor and patient you know, because healthcare rights matter. And now, the courts are protecting them. Thank you for watching.